to mistake of fact in law. In the field of law, the concepts of mistake of fact and mistake of law play a crucial role in shaping the outcomes of legal cases. Mistake of fact occurs when an individual's belief about a certain fact is incorrect, leading to unintended consequences. On the other hand, mistake of law occurs when there is a misunderstanding or ignorance of the law itself, which can also have significant repercussions. Definition and distinction between mistake of fact and mistake of law. Mistake of fact. In the realm of the law, a mistake of fact refers to a situation where a person's belief about a certain fact leads them to perform an action that would have been lawful if the facts were as a person believed them to be. It is a defense to criminal liability and requires a subjective assessment of the individual's state of mind at the time the act was committed. In essence, it pertains to situations where the individual is not aware of the true circumstances due to an honest mistake. Mistake of law. On the other hand, a mistake of law occurs when an individual is genuinely unaware that their actions are prohibited by law. This is distinct from a mistake of fact as it involves a lack of knowledge or understanding of the legal consequences of an action rather than a misperception of the factual situation. In general, ignorance of the law is not an accepted defense, but there are specific circumstances where it may be considered as legal analysis. Types of mistakes of fact. Unilateral mistake, mutual mistake, mistake as to identity, mistake as to existence of subject matter. Examples of mistake of fact cases. Mistaken identity, fraudulent documents, mistaken consent. Legal consequences of mistake of fact. Voidability of contracts. When a mistake of fact is made by one or both parties in a contract, it can be rendered contract voidable. This means that the mistake party has the option either affirm the contract thereby upholding its legal validity or to void the contract making it legally unenforceable. Criminal liability. In criminal law, mistake of fact can affect the culpability of an individual. If a person commits a crime under a genuine and reasonable mistake of fact, their criminal liability may be reduced or alleviated, as the mistake can negate the required mental state for the offense. Restitution and damages. When a mistake of the fact results in financial loss or unjust enrichment, the affected party may seek restitution or damages. This legal consequence aims to restore the injured party to their prior position or compensate them for the losses incurred due to the mistake. Types of mistake of law. Mistake of legislation, mistake of case law, mistake of executive order. Examples of mistake of law cases: tax laws, traffic violations, property laws. Legal consequences of mistake of law. When an individual makes a mistake of law, the legal consequences can be significant and far-reaching. It is crucial to understand that ignorance of the law is not an excuse, and individuals are generally expected to be aware of the laws that govern society. However, despite these general principles, there are situations where the legal system takes into account the genuine and reasonable mistakes made by individuals regarding the law. In some cases, a mistake of law may lead to civil or criminal liability. For instance, if an individual is unaware that a particular action is illegal and carries out that action, they may still be held liable for their actions. Similarly, in contractual matters, a mistake of law can potentially invalidate a contract, leading to legal disputes and financial consequences. Moreover, the legal consequences of mistake of law can vary based on the jurisdiction and the specific circumstances of the case. Courts may assess the reasonableness of the mistake and the impact it had on the individual's actions to determine the legal implications. Case laws, mistake of fact. State of Maharashtra versus M.H. George, 1965. In this case, the accused was charged with importing gold without a license, which was prohibited under these Customs Act. The accused argued that he believed he had a valid license, and the court held that these constituted a mistake of fact and acquitted him. Another case law, Bakshish Singh vs. State of Punjab, 1974. The accused, a police officer, arrested a person he genuinely believed to be a proclaimed offender, the arrested individual turned out to someone else, and the accused was charged with wrongful confinement. The court held that the accused had made a mistake of fact in good faith, and therefore could not be held liable. Case law in Mistake of Law. State of Maharashtra versus Meyer Hans Judge 1965. In this case, the accused was charged with violating the Sea Customs Act for not claiming gold he brought into India. The accused claimed that he was unaware of the law and believed that he was allowed to bring gold without declaration. The Supreme Court held that ignorance of the law can't be used as defense, but it can be considered as a mitigating factor in sentencing, especially when the law is complex or not well known. Another case law in Mistake of Law is Hari Ram vs. State 2009. The accused was convicted under the Narcotic Drugs and Physiotherapy Substances Act for possessing opium. He claimed he was unaware that possessing opium was illegal. The Himachal Pradesh High Court acknowledgement that ignorance of the law is generally not a defense, but it can be considered in cases where the law is highly technical or complicated and the accused had no reasonable opportunity to become